what I would want to know, what would satisfy the Commission when you leave this court and you have a judgment in your favor? What must that judgment say?
Order we would want from this court is an order saying that the findings and recommendations, a declaratory order saying findings and recommendations made by the Human Rights Commission exercising section 1842B of the Constitution, where a human rights violation has been found to have occurred, in certain instances are binding.
The case began back in 2018 when a community of dwellers on a Mpumalanga farm complained that the new owners had cut off their water. The SAHRC investigated, found their rights were being violated, and told the owners to restore the supply. The owners ignored them, so the Commission went to court arguing that not only should this order be enforced, but all SAHRC directives should be legally binding. But according to Pasha, the Supreme Court of Appeal disagreed, agreeing instead with AfriForum that the Commission simply doesn't have the kind of power. The debates quickly included other public institutions, with the Commission's counsel asking if the Public Protector can issue binding remedial action. Shouldn't the Human Rights Commission have similar muscle?
In the judgment of the ACA, does it say the Commission does not have the power to make findings of human rights violations?
Maybe a direct answer to that is that it doesn't say that power does not exist, but we read from it saying our powers are only limited to opinions, and how it interprets how those opinions have to be enforced by the court. We say that by itself means that the recommendations that we make can then not be binding.
Pasha argued that when it orders something like restoring water after finding a human rights violation, that should carry real force. But pushback came quickly. The counter-arguments giving the SAHRC binding authority could actually weaken it, taking away the soft power and persuasion it uses to get cooperation. And if Parliament wanted the Commission to issue binding directives, it could have written that into law, just like it did with the Auditor General.
It is by design that our Human Rights Commission doesn't have binding. We make an important point. Whatever else it is, the Human Rights Commission is not a court. And so, in light of the general access to court right in section 34, it cannot be said that those who are either accused of or are the victims of human rights violations are getting access to court when they are getting access to a complaints procedure in the human rights.
For now, the country waits, the court has adjourned, and judgment has been reserved. For Newzroom Afrika on Channel 405, I'm Ntokozo Khumalo in Johannesburg.